Honorable guests, ladies and gentlemen, good morning. Welcome to the forum on Doing Business in Hong Kong in a Rapidly Changing World. I'm Sharon Tam, member of the Standing Committee of Member Services of the Law Society of Hong Kong.
Good morning. I am Arthur Chan, member of the Young Solicitors Group of the Law Society of Hong Kong. It is our honor to be the MCs of the morning sessions of today's forum.
With unprecedented disruption arising from the pandemic, many countries and cities, including Hong Kong, have experienced rapid changes. Fortunately, with well-established legal and financial systems, direct access to the huge market in the mainland, as well as strong international connectivity, Hong Kong is able to thrive on change and remains resilient amidst unusual times.
To strengthen the international community's confidence in Hong Kong's long-term economic development and competitiveness in a rapidly changing world, which will in turn create more opportunities for the legal industry, this forum will explore Hong Kong's unique strengths and opportunities that can strengthen this city's status as a leading international legal and financial hub and a gateway to mainland China for doing international business.
With much delight, the forum today is well received by over 2,100 participants from various sectors of 31 jurisdictions physically and virtually. In particular, we're much honored to have 44 representatives of the Consulates General, honorary consulates, and officially recognized body from 26 jurisdictions to grace us with their presence.
We are also grateful to have distinguished speakers, our overseas and Greater China counterparts, and representatives from the government bodies, academia, legal and business sectors, as well as legal elites, chambers of commerce, and regulatory bodies from across the world with us today. Last but not least, we must mention the 38 supporting organizations for their dedicated support.
Without further ado, may we now first invite Mr. C.M. Chen, President of the Law Society of Hong Kong, to extend warm welcome to the participants. Mr. Chen, please.
Ladies and gentlemen, let me welcome you all to this important forum of the Law Society of Hong Kong. The title of today's event is Doing Business in Hong Kong in a Rapidly Changing World. The origin of this forum was a humble one. I was talking to my staff, I think last year this time, to hold an event, a forum for the international community, international investors. We were thinking to hold a forum at the premises of the Law Society. But yet, of course, the pandemic is now over. We have now a much more ambitious event here at the Convention Center with the help of the government funding. With the resumption of normalcy and Hong Kong SAR government support to partly fund this initiative, we are glad that we can hold this seminar in a much larger scale in Hong Kong's reputable convention center here, and face-to-face, more importantly, with interaction with the audience. It is indeed encouraging to see, like the MC just said, that we have over 2,000 registrants for today's event, including nearly 50 representatives from consulate generals in Hong Kong and chambers of commerce in Hong Kong. On the site today, as at the latest figure, we have representatives from over 26 jurisdictions. In today's forum, we will focus on three major areas. Number one, China's post-pandemic economic recovery. Number two, Hong Kong's inherent strengths. Number three, advantages of the Hong Kong legal services. China is, of course, the world's second largest economy. And according to the International Monetary Fund, China now accounts roughly, not exactly, roughly 20% of the world GDP. The recent figures show that China's post-pandemic recovery is firmly underway. It is recorded a 4.5% growth in GDP and a 14.8% growth in exports in the first quarter of 2023. It is worth noting that China's GDP growth is higher than the expected 2.8% growth rate globally, as per the International Monetary Fund's forecast. Such rapid economic growth in China may unlock a faster global recovery. This is because national policies such as the Belt and Road Initiative, the Guangdong, Hong Kong, Macau Greater Bay Area Development, GBA in short, and the Regional Comprehensive Economic Partnership Agreement, RCEP, bring international connectivity and economic cooperation in sharp focus. Opportunity for global investors' business expansion abound, while Hong Kong is best placed to connect with them with the enormous mainland China market. Moving on to Hong Kong itself, like many other places, we have impacted by the pandemic quite hugely. Fortunately, the city remains vibrant and resilient, has resumed normalcy, and is back on the world stage. Studies released earlier this year continue to recognize Hong Kong's competitiveness, as the city was ranked as the world's #1 for investment environment, world #2 for infrastructure and market access, world's #4 for global financial center, etc., by different international institutes. Hong Kong has also been picked as the world's freest economy since 1996 by the Canadian-based Fraser Institute. Geographically speaking, Hong Kong has direct access to the mainland market and at the same time a strong international network. Its location at the heart of the Asia-Pacific region provides businesses with unparalleled access to mainland China and some of the world's fastest growing economies. Hong Kong's world-class infrastructure, such as airports, seaport, and telecommunications network, supports the smooth flow of goods, services, talents, and information. Meanwhile, Hong Kong's soft power is equally important. The city's competitiveness is underpinned by its unique strengths under the one country, two systems principle, including the adoption of the common law system, an independent judiciary, a favorable business environment, a transparent market, a simple and low-tax system, a regulatory regime in line with international rules, an efficient and clean government, and a world-class professional services, of course, including the legal profession. It's not complete to discuss doing business in Hong Kong without considering the role of the Hong Kong legal sector. China's 14th five-year plan supports Hong Kong in developing itself into a center for international legal and dispute resolution services in the Asia-Pacific region. Hong Kong's legal system is renowned for its impartiality, transparency, and efficiency. Hong Kong was ranked Asia #3 for rule of law and regulatory quality by the World Bank Group, Worldwide Governance Indicators 2022. As the only common law jurisdiction in the whole of China and the only city in the world that has a truly bilingual common law system, Hong Kong adopts a law system that is flexible but yet predictable towards doing business. Further, Hong Kong has a strong pool of talents, legal talents especially, who are capable in dealing with international legal matters. In addition to the 13,000 local solicitors, there are over 1,400 registered foreign lawyers from 33 different jurisdictions working in Hong Kong. They are all members of the Law Society of Hong Kong. There are, in fact, 75 registered foreign law firms in the city, providing a diverse range of legal services. Hong Kong is also one of the most preferred locations for dispute resolution. When contractual disputes arise, our dispute resolution experts can help achieve resolutions in a timely and cost-effective manner. With the set advantages and its unique positioning, Hong Kong lawyers can act as a super connector to support mainland enterprises in going global and worldwide investors in entering mainland market. There's an ancient saying, the only constant in life is change. In the past few years, the world, Hong Kong included, has undergone a whole host of changes at an accelerated speed. It is more important than ever for us to regroup among ourselves, recollect our inherent strengths, and restart our efforts to navigate changes that can actually lead to opportunities and growth. This forum gathers overseas and local government officials, business representatives, academics, and legal practitioners. They are going to share their direct experience in doing business in Hong Kong and the pertinent legal topics of concern, particularly informative to the international community, which has all along played an integral part of Hong Kong's economic and legal development. We hope that through open, frank, fact-based discussions and exchange, this forum will facilitate an objective and a more complete understanding of Hong Kong's robust business environment and legal system. Operations with confidence by businesses and further development of Hong Kong as a leading international legal and financial hub and a gateway to the mainland China. Before I close, I would like to extend my warmest gratitude to our guests, speakers, participants, supporting organizations, sponsors, and organizing committee of this forum, and of course, Hong Kong SAR government's Professional Services Advancement Support Scheme, PASS in short, for making this event happen. I really hope you enjoy the rest of today, and I hope you stay till the end. Thank you for your attention. Thank you.
Thank you, Mr. Chan. Please be seated. May we now invite the Honorable Mr. Paul LAM Ting-kwok, Secretary for Justice of the Government of the Hong Kong Special Administrative Region of the People's Republic of China. Mr. Lam, please.
Mr. CM Chan, Chen Dong 副主任, Feng Jianming, 副特派员, distinguished guests, ladies and gentlemen, a very good morning to everyone joining us here in person and online. And I wish to begin by thanking the Law Society of Hong Kong for inviting me to this forum. July 2023 marks the completion of the first year of the term of the current Hong Kong SAR government, as we recover from unprecedented challenges in the past few years. The world we live in today is indeed changing rapidly. The topic for today's forum, doing business in Hong Kong in the rapidly changing world, could not be timelier. As the Chief Executive remarked earlier this month, in celebration of the 26th anniversary of the establishment of the Hong Kong SAR government, Hong Kong has emerged from the shadow of economic contraction, and we are now moving full steam ahead in an upward trajectory of economic growth. Despite the challenges experienced in the past few years, based on objective information, I'm very confident that Hong Kong is resilient and remains as a leading international financial center and an ideal place for doing business with its pro-business policies, low tax system, etc. The statistics released by the Census and Statistics Department in March this year shows that Hong Kong continues to be a prominent financial center. At the end of the fourth quarter of 2022, both Hong Kong's external financial assets and liabilities stood at a very high level, amounting to 47,437.8 billion and 33,685.8 billion respectively. As at the end of February 2022, Hong Kong is home to 78 of the world's top 100 banks. It's the world's largest offshore renminbi hub, with total deposit of renminbi 924.9 billion. It ranked the 4th in the world and 2nd in Asia for funds raised in 2021. In a rapidly changing world, Hong Kong supports new development to complement our traditional financial markets. And even throughout the difficult pandemic time, Hong Kong continued to excel in its thriving startup sector. Invex Hong Kong's 2022 startup survey showed that both the number of startups and the number of employees reached a record high, with a total of 3,985 startups employing close to 15,000 staff members. And to put things in perspective, in comparison to 2018, there's an increase of 52% in the number of startups set up in Hong Kong, and 56% increase in the number of staff employed. In 2021, 18 unicorns have emerged from Hong Kong with successful stories of companies listed on the Hong Kong Stock Exchange, as well as NASDAQ in the United States. I firmly believe Hong Kong's ability to remain as an international financial center is largely attributed to a stable environment with strong rule of law consisting of a robust legal system and a pool of diversified legal talents. During his visit to Hong Kong in July last year, President Xi emphasized in his speech that the principle of one country, two systems must be adhered to in the long run. And it's most significant to note that he mentioned common law twice in the speech, highlighting the need to maintain and develop the same. And under the principle of one country, two systems, Hong Kong retains its common law system and remains to be the only common law jurisdiction within China. Court hearings are conducted or can be conducted in either English or Chinese, and all court proceedings, save for very limited exceptions, are open to the public. Court judgment and also reason for sentence in criminal cases for district court and above are available on judiciary website. As guaranteed under the Basic Law, our judiciary exercises independent power of adjudication free from any interference. Article 85 of the Basic Law allows our Court of Final Appeal to invite eminent foreign judges to sit as non-permanent judges. Currently, there are 11 foreign MPJ, including the recently appointed the Honourable Mr. Justice Patrick Anthony Keane from Australia. Now, these foreign judges from United Kingdom, Australia, and Canada are highly regarded in their own jurisdictions and bring with them international judicial experiences which enrich Hong Kong's jurisprudence. Judgment of our Court of Final Appeal are cited by the court in other common law jurisdictions from time to time. Major economies and international business community are familiar with our common law system. With Hong Kong's impartial, independent, and transparent judicial system, international business community is assured with a predictable, certain, and secure legal environment which is conducive to investment and business activities. In order to maintain a stable environment, Hong Kong must not ignore or underestimate any possible risk to national security. The enactment of the National Security Law not only safeguards our national sovereignty and territorial integrity, it also provides a stable and peaceful environment, which is indeed an essential precondition for business development and enjoyment of activities for both overseas tourists and people living and working in Hong Kong. Hong Kong is certainly not the only jurisdiction with national security laws. Most, if not all, jurisdictions, including, for example, United States, United Kingdom, Australia, Canada, and Singapore, have enacted some form of national security legislations, many of which are even more stringent than the NSL. Foreign media's narrative of Hong Kong's NSL tends to be negative, untrue, and unfair with twisted facts, portraying NSL as a draconian law that should be feared by all. But in fact, since the implementation of NSL 3 years ago, as at 7th of July in 2023, only 30 persons have been convicted or are waiting for sentencing under the NSL, which is an extremely small number compared to Hong Kong's 7 million population. Open judgment of NSL, setting out the facts and reason of those cases, which invariably involve very extreme and radical acts, show that people engaging in normal business have no reason whatsoever to be concerned. Rising geopolitical tensions and increasing protectionism may have generated false political rhetoric. At the AALCO Forum Asia held in April this year, Presidency emphasized the need to uphold true multilateralism through safeguarding peace, advance cooperation, and to jointly promote Asian unity. This year marks the 10th anniversary of the Belt and Road Initiative. And as remarked by Presidency in May this year, the ultimate purpose and goal of this initiative is to explore new ways for countries from near and far to achieve common development, opening up a path of happiness that benefit the world. The National 14th Five-Year Plan supports Hong Kong to develop in 8 key areas, and among others, a Center for International Legal and Dispute Resolution Services. The outlined development plan for Guangdong, Hong Kong, Macau Greater Bay Area aims to further deepen the cooperation among the 3 jurisdictions within our country, opening up vast opportunities in 9 mainland cities with a population of over 86 million and GDP of over renminbi 13 trillion in 2022. The objective of these national policies is clear: to build a community with shared goal for common kind. Hong Kong proactively integrates into these national policies, bridging business between the Chinese market and the rest of the world. Today, Hong Kong has signed 9 arrangements on legal mutual assistance in civil and commercial matters with the mainland. These arrangements can be broadly categorized into 3 areas, namely procedural assistance, arbitration-related assistance, and reciprocal recognition and enforcement of judgment. The MLA regime is a strong testimony to the principle of one country, two system, under which Hong Kong maintains its own legal system on the one hand, and continue to collaborate with the mainland to enhance our legal and dispute resolution service to facilitate increasing cross-border trade and investment, thereby proactively contributing to national development. With a strong pool of around 13,000 solicitors and 1,600 barristers, it's not difficult to find a Hong Kong legal practitioner with multi-regional experiences, proficiency in multi-languages, and expert legal knowledge, providing top-notch professional legal and dispute resolution services for cross-border transactions and business activities. Hong Kong's legal practitioners can now obtain GBA qualification to practice in the 9 GBA cities in specific civil and commercial matters to which mainland law apply. With dual qualification, Hong Kong's legal practitioners have an edge in providing one-stop service for cross-boundary transactions. Furthermore, Hong Kong and other foreign invested enterprises registered in Qianhai Cooperation Zone in Shenzhen have the option to choose Hong Kong law as the applicable law, and for those in the free trade zone in the mainland to choose Hong Kong as a seat of arbitration in the civil and commercial contracts. We will continue to actively seek the support of the Central People's Government in extending the initiative to all GBA cities. Hong Kong is constantly ranked among the world's top 3 most preferred seats for arbitration. Arbitral awards made in Hong Kong are enforceable in over 170 contracting parties under the New York Convention. Our arbitration ordinance has been amended over the years to assure that the Hong Kong's arbitration law stay abreast of international development, with the most recent amendment in last December to allow flexible outcome-related fee structure arrangement in arbitrations. With the mediation culture taking root in Hong Kong, we have begun to bring our Mediate First brand outside of Hong Kong. The Joint Conference of Legal Departments of Hong Kong, and Macau have endorsed mediator accreditation standards, code of conduct and best practice, and cross-boundary dispute mediation model rules, contributing to the wider use of mediation in GBA. With the staunch support of the Central People's Government, the International Organization for Mediation Preparatory Office was established in February this year. It's envisaged that the Preparatory Office will become a permanent multilateral international organization established through negotiation among contracting parties, providing friendly and efficient mediation service for resolving international disputes. A robust legal infrastructure, independent judiciary, a safe and secure environment are key considerations for business operating in Hong Kong. With the support of our motherland and abundant opportunities under national policies, Hong Kong will continue to contribute to the shared vision of common development in this rapid changing world. And on this note, I wish today's forum every success. Thank you very much.
Thank you, SJ. Please remain on stage. May we invite the following guests to come onto the stage for a group photo, please. Mr. C.M. Chen, President, the Law Society of Hong Kong. Mr. Chen Dong, Deputy Director of the Liaison Office of the Central People's Government in the Hong Kong Special Administrative Region. Mr. Fang Jianming, Deputy Commissioner, Office of the Commissioner of the Ministry of Foreign Affairs of the People's Republic of China in the Hong Kong Special Administrative Region. Mr. Amarali Nasir, MHJP, Vice President of the Law Society of Hong Kong. Mr. Roden Tong, Vice President of the Law Society of Hong Kong.
Mr. Hyun Wong, SBS, BBS, JP, past President of the Law Society of Hong Kong. Mr. Ambrose Lam, JP, past President of the Law Society of Hong Kong. Dr. Thomas So, JP, past President of the Law Society of Hong Kong. Mr. Ronald SUM, JP, Council Member and Chairman of the Forum Organizing Committee of the Law Society of Hong Kong. And Ms. Heidi Chu, Secretary General of the Law Society of Hong Kong.
Thank you very much. Would other guests please be seated? This brings us to a close of the opening session. We will now have a 10-minute break before commencing the panel sessions. The first panel session will start at 9:45 a.m. For the online participants, there's no need for you to log out of the session, and see you all in a bit. Ladies and gentlemen, welcome back. We have now come to the panel session of the forum. Before the session begins, here are some housekeeping reminders. There will be a Q&A session after the speakers sharing for each session. We welcome guests on site to write down any questions that you have for the speakers on paper and hand it over to our colleagues. For the participants joining via Zoom, you may type your question in the Q&A box during and after the presentations.
Let us now begin our first session. Hong Kong, preferred seat for international commercial arbitration and preferred place for international mediation. In this session, legal elites would shed light on Hong Kong's unique strengths in corporate and commercial legal services and illustrate why Hong Kong is an effective arbitration and mediation platform for resolving commercial disputes.
Please allow me to introduce the moderator of this session, Mr. Ronald SUM, Council Member and Chairman of Forum Organizing Committee of the Law Society of Hong Kong. May we also welcome the following speakers to join Mr. SUM for the discussion. Dr. Thomas So, JP, Past President, the Law Society of Hong Kong and Chairman of EBRAM. Dr. Anthony Neil, SCJP, Co-Chairman, Asian Academy of International Law. The Hon Mr. Justice Johnson Lam Man Hon, Permanent Judge of the Court of Final Appeal, Hong Kong Special Administrative Region. The Hon Teresa Cheng Yeuk-wah, GBM, GBS, SCJP, Former Secretary for Justice, the Government of the Hong Kong Special Administrative Region. The Hon Rimsky Yun, GBM, SCJP, Co-Chairperson, Hong Kong International Arbitration Center and Chairman of Hong Kong Mediation Accreditation Association Limited. And last but not least, Mr. Nick Chan, MHJP, Director, Asian African Legal Consultative Organising, Hong Kong Regional Arbitration Center. The time is over to our moderator and speakers, please.
Thank you very much. Good morning, ladies and gentlemen, honored guests, fellow Law Society members present in this conference room or online. Welcome. Well, my name is Ronald SUM. I am the moderator for this first session. Hong Kong, preferred seat for international commercial arbitration and preferred place for international mediation. I'm also the chair of the organizing committee for this event. By practice, I am a partner at Baker McKenzie, Hong Kong. Now, before I introduce the very prominent guests on stage and off the stage, I think none of them needs a thorough introduction. Why start off this hot Tuesday morning in this rather interesting topic? I was having a chat with Teresa the other day, and we were talking about what session to start first. There were discussions about starting this event on something non-dispute resolution. The reason is that if there is no business in Hong Kong, there will not be any dispute resolution. Very true. Okay. But according to a recent survey done by the International Chambers of Commerce Hong Kong, the International Dispute Resolution Service is actually ranked very high in the survey. As a matter of fact, the rule of law, independent judiciary are also ranked very, very high in the survey. Now, also later on, I asked some of the business leaders in Hong Kong, and one of the main criteria, they told me choosing Hong Kong as a forum to do business is in fact the dispute resolution mechanism to be regarded rather highly before they think about investing in Hong Kong or investing in the mainland through Hong Kong. Now, with that said, let me introduce the prominent speakers for today. Now, if I have to introduce each of them according to their script, it will take me an hour to do so. So I'm going to summarize it, and I don't think you are here to listen to me, but listen to all the prominent speakers in talking about arbitration, mediation, why is the preferred seat for arbitration and mediation in Hong Kong. Let's start off with, on alphabetical order, Mr. Nick Chan, MHJP. He's the director of AALCO Hong Kong Regional Arbitration Center. The long name for AALCO is Asian African Legal Consultative Organisation. It is an inter-government organization with 47 members countries. Now, Nick Chen is also a Medal of Honor recipient and the Justice of Peace. He's a good friend, and he's a lawyer with 25 plus years of experience who have worked in-house with regional responsibilities and have computer science background. On top of that, he is also the chairman of the Legal Committee of the Hong Kong General Chambers of Commerce. Thank you, Nick, for joining us today. The next one is Teresa, the Honorary Teresa CHENG, GBM, GBS, SCJP. Very nice photo, obviously, as you can see from the brochure. Teresa is a senior counsel, chartered engineer, chartered arbitrator with a distinguished record of public service in the Hong Kong SAR. Between January 2018 to 2022, Teresa was the Secretary for Justice of the Hong Kong SAR. She is also a member of panel of arbitrators of ICSID, first designated by the chairman of the Administrative Council in 2011 and by China in 2017. Once again, she's also a good friend. She specializes in a wide range of legal areas, including construction, shareholders' disputes, international commercial contracts, and investment disputes, and is an experienced practitioner in arbitration and mediation. So welcome, Teresa. Thank you. The next one is the Honorary Mr. Justice Johnson Lam, Permanent Judge of the Court of Final Appeal, Hong Kong Special Administrative Region. Mr. Lam, Justice Lam, was appointed a Permanent Judge of the Court of Final Appeal on 30th of July 2021. Justice Lam joined the judiciary as a district judge in 2001. In 2003, he was appointed a judge of the Court of First Instance. He was a president of the Lands Tribunal from 2003 to 2009, and a probate judge from 2008 to 2011. From 2011 to 2013, he was the judge in charge of the Constitutional and Administrative Law List. He was appointed a Justice of Appeal in 2012 and became the Vice President of the Court of Appeal in 2013. Now, to me, Justice Lam is a knight, okay, leading the charge in the mediation front in Hong Kong. So thank you very much, Justice Lam. Dr. Anthony Neo, I'm just calling him Tony, KC, SCJP. Now, Dr. Neo, Tony, is a senior member of the Hong Kong Bar, specializing in international litigation, arbitration, and financial regulatory matters. Now, going back a bit of history here, in 1979, he commenced practice at the Hong Kong Bar after serving for 13 years in the Hong Kong Civil Service. From 1991 to 1994, he was a member of the Hong Kong Stock Exchange Council and its listing committees, and chaired its disciplinary committee and debt securities group, and was the co-chairman of the legal committee of the Hong Kong and China listing working group. He was the chief architect of the legal structure for the listing of Chinese enterprises in Hong Kong. He is the former chairman of the Hong Kong Securities and Futures Commission from 1995 to 1998. During that time, he was the first Asian to be elected chairman of the Technical Committee of the International Organization of Securities Commission. From 1999 to 2004, he was the chief advisor of the China Securities Regulatory Commission at the personal invitation of former Premier Zhu Rongji. Dr. Neo was appointed as chairman of the Hong Kong Independent Police Complaints Council from June 2018 to 2021. And of course, now he is the co-chairman of the Asian Academy of International Law. Welcome, Tony, and thank you for joining us. Dr. Thomas So, JP, he needs no introduction, being the past president of the Law Society of Hong Kong and chairman of EBRAM. I think he will talk about more about the state-of-the-art technology of EBRAM in Hong Kong. Dr. Thomas So is a partner of Ronald SUM law firm. He advises on shareholders and equity-related disputes, property-related litigation, libel litigation, and media-related litigation work, and litigation and arbitration in the mainland. He represents banks and financial institutions, property developers and corporations, as well as mainland Chinese enterprises on securities and equity-related disputes. Dr. So was praised by the Legal 500 Asia Pacific for providing sound knowledge and practical solutions to clients. Chambers Asia Pacific describes Thomas as instrumental in many cross-border cases. Obviously, Dr. So has acted as arbitrator and mediator in a number of disputes, commercial disputes. Welcome, Thomas, in joining this session. Last but not least, Rimsky. Mr. Rimsky Yuen, GBM, SC, JP. Now, from 2012 to 2018, Mr. Yuen was the Secretary for Justice of the government of the Hong Kong SAR. After resigning as the Secretary for Justice, he resumes private practice at Temple Chambers with focus in commercial disputes. A lot of the audience here, both in the room and online, has probably instructed Rimsky a number of times. Mr. Yuen also practices as arbitrator and is a panel member of various local and overseas arbitral institutions. In addition, Mr. Yuen is an accredited mediator and practices as general mediator with emphasis on commercial and related civil disputes. He is the co-chair of the Hong Kong International Arbitration Center, short for HKIAC, and also the chairman of the Hong Kong Mediation Accredited Associations. So his practice spans across both arbitration and mediation. He is a committee member of the International Commercial Expert Committee of the China International Commercial Courts. So thank you, Rimsky. Give a big hand to Rimsky in joining in this session. Of course, given the size of this stage and probably the size of me, we cannot fit in one more chair. We actually have a very prominent and seasoned arbitrator, okay, on the floor. He is actually the chair of the Arbitration Committee of the Law Society of Hong Kong. If I'm not mistaken, he is also one of the founding forefathers of HKIAC in Hong Kong. Mr. Yeuk-wah. And of course, Mr. Yeuk-wah, this time I got it right, has got too many titles that I've forgotten how to even mention his title. Okay. Now, that took a bit of time in the introduction. Now, dispute resolution mechanism includes litigation, arbitration, and mediation. What better place to start my questions, okay, is towards Justice Lam from the judiciary. So, Justice Lam, okay, to warm everyone up in this hot Tuesday morning, the first question is, to what extent the laws in Hong Kong party autonomy in the mechanism for resolution of commercial disputes?
Thank you. Most commercial disputes stems from contractual rights and obligations. Nowadays, many contracts contains provisions like dispute resolution clause, choice of law clause, and choice of forum clauses. And by utilizing these clauses, the parties are free to decide what is the law to be applied to their dispute and where would they resolve their dispute and what process they will engage in trying to resolve the disputes. As far as the laws in Hong Kong is concerned, we pay full weight to these choices of the parties. I can just illustrate this by citing from a most recent judgment of the Court of Final Appeal in the case of CND, in which the Chief Justice had this to say with regard to party autonomy dispute resolution. The Chief Justice said, in arbitration, the jurisdiction of an arbitral tribunal is essentially agreement-based. Leaving aside jurisdiction conferred by statute, it depends, and indeed wholly depends, on the content and extent of the parties' consent to arbitration. Given the freedom of contract, it is up to the parties to agree what matters should be left to be decided by the arbitral tribunal and what should not. By definition, given their autonomy, the parties are not bound by any jurisdiction admissibility distinction as such. In other words, in the context of arbitration, the word jurisdiction, or the jurisdiction of a tribunal, has no fixed definition, but is ultimately dependent on the parties' agreement, reflecting their consent to arbitration. Another recent case of the Court of Final Appeal, in the case of Guy Lam, decided in May this year, the court held that bankruptcy proceedings is issued in Hong Kong. The proceedings should be stayed as a result of the contract providing for exclusive jurisdiction in the New York court. So these cases do illustrate how the extent to which our courts are prepared to go to respect parties' autonomy. And at the same time, we are also very pro consensual dispute resolution processes. So as you will hear later on, we have a lot of measures to encourage and facilitate parties to do that.
Thank you, Justice Lam. I would love to comment on the CND, but cannot because we are one of the lawyers involved in the CND. Okay. Also, in relation to mediation, more concerned with litigation, is that after the commencement of litigation, how would the courts in Hong Kong encourage or facilitate the use of ADRs? I've heard many people saying that mediation, it may be a waste of time. I've ventured into litigation, pay all the legal fees. Why stop and spend further money on it? Can you shed some light on it?
Yes. We see the engagement in other processes to resolve dispute, not confining to mediation, any other alternative dispute resolution mechanism, as a parallel to litigation in the sense that it would not stop just from after a commencement of litigation. It is an ongoing process. As we all know, the old days, people continue to negotiate for settlement after they start proceedings. But likewise, for other alternative dispute processes, there's no reason why you should stop engaging in those processes after started litigation. And actually, we have issued a practice direction 31 to direct people's mind to consider the using of these alternative resolution processes. Because as judges, we see many cases fighting in court, which is not quite worth the while in terms of the time and the money and also the energy spent in it. Under the practice direction, the parties are required to address their mind to the question of whether the matter can be resolved by way of mediation. They have to tell the court whether they intend to use mediation or at least to try mediation. And if they don't intend to do so, they have to give a reason. Then at the case management hearing, master will have a look at the answer and also explore with them whether the answer, that their thinking is correct or whether there could be another way to look at it. In all these processes, we sort of assist the party to address, firstly, to whether to consider alternative dispute resolution process. And secondly, if they were going to do so, we match them together. We will put the two parties together, and so they can take things forward by way of mediation. So that is one of the measures that we have introduced since, I think, 2011 to encourage people to explore mediation.
Thank you, Justice Lam. Later on, I'm going to route back into what you have just mentioned, the case settlement conference and the mediator-assisted case settlement conference later on. Now, let's take a break from litigation, mediation, and back to a more general discussion. I'll direct this question to Rimsky. I think I have actually mentioned his name right this time, not Mr. Yuen-wah. So Rimsky, can you being the chair of one of Hong Kong leading arbitration institutions, the HAIC, can you give a brief outline of the dispute resolution services in Hong Kong?
Thank you, Ronald. I think on the whole, I would describe Hong Kong dispute resolution landscape as a very mature one. Because apart from the conventional court litigation handled by our independent judiciary, we have quite a lot of different forms of dispute resolution. The major ones, of course, include arbitration, mediation, and apart from these, we also have adjudication, which is more relevant in the context of construction industry. But there are also other forms such as expert determination. So I think in short, basically the major forms of dispute resolution, in particular arbitration and mediation, are available in Hong Kong. And I think the important point to note about Hong Kong's landscape in the context of dispute resolution is that we always say dispute resolution do not take place in a vacuum. And it is necessary to have the relevant, if not strong, legislative framework to support the conduct of dispute resolution and to ensure that the process would be a fair, cost-effective, and worthwhile one. And in this regard, I think Hong Kong has a very good legislative framework for the major types of dispute resolution. In the context of arbitration, of course, we have the arbitration ordinance to enable the parties to have a smooth and effective as well as fair process of arbitration. We're also parties to the New York Convention, and we have also arrangements which are along the line of New York Convention with mainland China and Macau. So effectively, from the beginning of arbitration up to the enforcement of an award in the context of arbitration, Hong Kong has a very mature regime. And the same can be said about mediation. Not many jurisdictions has legislations concerning mediation. But in the context of Hong Kong, we have the standalone mediation ordinance. We also have the apology legislation, which from our experience and from our survey shows that the apology ordinance is extremely effective in facilitating settlement in the context of mediation, particularly in sectors such as the medical sector. So these are the key features of Hong Kong dispute resolution landscape. And I think another feature which I would like to stress just by way of introduction for different members of the panel will discuss other matters, that the system is being kept under review constantly. Actually, if you look at the law reform in Hong Kong from the 1980s up till now, particularly in the past 10 years, you will see that there are constant law reform, constant legislative amendment relating to dispute resolution. Why? The reason being that we take the view that the world is changing, And in particular, if you look at look around the world in the context of dispute resolution, things are moving quite fast, and therefore, one of the key features of Hong Kong's dispute resolution landscape is we look around, we measure, engage the needs of the end user. We see what have been changing in the dispute resolution community, not just locally, but worldwide and globally. And then we will bring in legislative changes. And the key examples we have over the years, a more recent one would be the third-party funding, the changes in relation to allowing intellectual property use to be a subject matter of arbitration. And then there are other changes which, in a way, ensure that what the international community expect, you will see that in Hong Kong, and that they are familiar, they are on par, if not at the forefront of the international community standard. I hope that will give you a bird's eye view of our system. Thank you.
Thank you, Rimsky. Under your leadership, or as the chair of the HKIAC, HKIAC has been named as one of the top 3 international arbitration institutions for this year and for past years. What do you think are the key factors that contribute to this success?
I would attribute the ranking of HKIAC a number of factors. I think, as I alluded to earlier, HKIAC cannot do the job on its own without a good environment. And Hong Kong has that environment, in particular, the legislative framework, the arbitration, and also the arrangements, the various arrangements that we have entered into with mainland China, including enforcement. There's also the arrangement in relation to court aid interim measures. So the landscape itself, the legislative framework in Hong Kong itself, provide a very conducive environment. We also have a very strong pro-arbitration judiciary. Justice Lam has just mentioned about cases that, in fact, there have been cases decided in Hong Kong by the Hong Kong judiciary, which are landmarked in common law landscape dispute resolution jurisdiction. So that goes to show that both the legislation as well as the judiciary is a strong support to the work of HKIAC. Internally, I am most grateful to the very hardworking Secretariat of HKIAC. In fact, both anecdotal evidence as well as formal survey shows that the Secretariat of Hong Kong HKIAC is one of the best respected Secretariat among arbitration institutions in Hong Kong. Of course, we also have a very effective set of arbitration rules because, like our legislations in Hong Kong, we constantly review the rules of arbitration announced by HKIAC, again, with a will to ensuring that the needs of the end user would be met, so that things like interim measures, things which are in the past have difficulties such as consolidation or dealing with different arbitration with common background at the same time, all those matters are being catered. And of course, the new phenomenon of third-party funding. So rules is one thing. The people are another aspect. We have a very good set of rules. We have a very good secretariat, which ensure that things and cases are being administered very effective. And of course, the whole operation and the whole process of arbitration administered by HKIAC is very transparent, because in terms of fees, in terms of the progress, each stage of the cases being administered are being handled with transparency. And you will have a rough idea as to how things will be moved, how much would be the cost involved, and these are in a way, these are the stuff which the end users of dispute resolutions decide. Thank you.
Thank you, Rimsky. Now, Tony. Today's forum is on doing business in Hong Kong in a rapidly changing world, when Hong Kong is known to be a place where the East meets the West. So it's all international. Now, since you are the co-chair of the Asian Academy of International Law, may I ask you why international law is important to dispute resolution?
Well, thank you, Ronald. I think one must start from the general proposition as to why international law is important to Hong Kong. Hong Kong, as we all know, is an international financial center. It is a free port, it's an international transportation hub, and one of the most important connectors of the financial and commercial system in the mainland. But the fact that international law is important really comes not only in the physical situation and the environment in which we all live in, but it really comes into Hong Kong through a very unique constitutional system we have, which is the system of one country system. And we are part of the People's Republic of China. And as a result of that, we are the beneficiary of all the international conventions and treaties that the People's Republic of China has entered into with all the many countries in the world, including, of course, the United Nations and many of the specialized agencies of the United Nations, all the bilateral treaties that China has entered into, and therefore we are the beneficiary of that. That is very, very important. That's one aspect of that. The second aspect, and which actually I would think underlines the uniqueness of our system, is that Hong Kong, as a special administrative region under the Basic Law, we are delegated with the authority to enter into economic arrangements as well as judicial and legal arrangements with other jurisdictions, including countries and jurisdictions within countries, by ourselves. To give you just one example, I mean, Cathay Pacific is our local airline, but we actually have the ability, because under the one country, two systems, to actually negotiate air service agreements between Hong Kong and all the sovereign countries of the world, so that Cathay Pacific, in fact, can have flying routes to all the countries as well, which is why we have a unique Hong Kong airline. Now, I remember when I worked for the colonial government, 13 years, now we actually have to fight with Whitehall in order to actually negotiate air service agreements between Cathay Pacific and other countries. Now, we don't have to fight with the central government at all. We are unique. We can actually negotiate our own air service agreements. Now, that is just one example. We have, for example, in other areas, such as investment protection agreements that we have with ASEAN countries. We actually have a very important investment protection agreement with all the ASEAN countries, whereby Hong Kong directly entered into this agreement. Hong Kong also has trade agreements with many countries. Hong Kong also actually is about to enter RCEP, which is an important regional economic construct. So again, because of this, we do have this uniqueness. The other uniqueness is that we do have a voice in international arrangements or the international rule-based order. We have a voice in almost every sphere, either by ourselves or through the central government. We have a voice, for example, in the WHO, for example, because of COVID-19, through, in fact, our central government. We have a direct voice in the World Trade Organization, and we recently won a case, incidentally, against the United States when they tried to label us, in fact, as being Hong Kong is being made in China. We say, no, that's not the case. Hong Kong is actually a member of the WTO. So we are autonomous in that regard. So therefore, we won the case, incidentally. But of course, the US is taking us to appeal, but there is no appellate body at the moment because the US, in fact, decided not to nominate anybody to that appellate body. But that's another story. So therefore, we do have, the benefit of the international arrangements of our mother country. We have the benefit of autonomy in relation to economic activities, we also have a voice. So those are the three important uniqueness. In terms of dispute resolution, because of this uniqueness, Hong Kong, of course, as Rimsky told us, is very much has the benefit of the New York Convention, 166 countries, whereby we can actually have our awards being enforced in these countries. We also, because of the one country, two systems, two systems, we have the ability to enter into juridical agreements or judicial agreements between Hong Kong and the mainland. And for example, we have many agreements for acceptance of service of process. We also have, for example, acceptance of mutual acceptance of judgments, but also we have a mutual acceptance of arbitration awards, as well as interim measures, which in fact no other place has. When Teresa negotiated that when she was the Secretary of Justice. So we have something which is extremely unique in terms of our constitution, which is why international law is so important. But it is important because of this unique constitution.
Thank you, Tony. You have heard both President CM Chen and the Secretary for Justice Paul LAM mention about one of the key drive in Hong Kong is also the professionalism, the breadth of knowledge of Hong Kong. Now, is there sufficient capacity within the Hong Kong legal profession to meet the challenges that international law poses?
I would absolutely think that we have sufficient capacity, but I would think that sufficient is not enough. It has to be, in fact, better all the time. But we do have sufficient capacity because Hong Kong, the lifeblood of Hong Kong is actually international context. And hence, of course, the lifeblood is part of all of us. You, me, everybody, including, of course. And therefore, we have, in fact, within the DNA of our legal practice, we have every aspect of international law really ingrained into us in the legal education that we get, also in our practice, everyday life, and therefore very much so, we have imbibed, in fact, sort of the international rule-based order. But I would think, however, because as Rimsky very rightly points out, we live in a changing world, and it's changing very fast. And as a result, really, we all have to come together, really, to improve our game. A handicap of less than 20, not good enough nowadays. It has to be less than 10. And then as a result, of course, we really have to improve. And which is why I think all of us have to.
Well, thank you, Tony. Now, obviously, Tony mentioned about the importance of international law. Many of our audience here do have the DNA of international laws. Now, of course, my next question is actually to Teresa. I'm going to route back onto what Teresa have done. For example, we have already heard numerous times today about the interim measures, the third-party fundings, paving the way and to make it easier for the mutual recognition of arbitral awards between Hong Kong and the mainland. But I know, Teresa, you have a special thing for international laws, okay, especially investment laws. Okay. Now, Hong Kong agreements on promotion of trade and investments has not used exit. Okay, funny enough, we change. I mean, and this is one of your favorite topics. Now, what's the main difference between exit arbitration and other arbitrations in the investor-state disputes?
Thank you, Ronald, for that question. It's one of my favorite subjects because I think it's very important to appreciate that when we are looking at promotion and protection of investment, we need to have a very good system to resolve the disputes. For years after the reunification with the motherland, Hong Kong has not yet been able to invoke the exit provisions, the Washington Convention, because we have not yet been designated as a constituent subdivision of China after 1997. That has been rectified, if I can use that word, in last year. So last year, Hong Kong has been designated by the central government to be a constituent subdivision or agent of the Exit Convention, meaning that nowadays, if Hong Kong enters into, and which Hong Kong has entered into a number of agreements, investment agreements with other states, we will be able to use, or the two, Hong Kong and the other states, can agree to use exit as the dispute resolution mechanism. The one attraction, the main attraction, I think, of the exit, there are many, but one of them that I think can distinguish other arbitration scenario is that exit arbitration is a-national. That is, it's not seated at any place. It is actually without a seat. And of course, the second thing arising from that is that the exit award in the investment dispute will rank as high as the court judgment of the land. In other words, insofar as an exit award is concerned, that will have the equivalent legal force as a CFA judgment in Hong Kong, and it will immediately be enforceable within the relevant state or the relevant jurisdiction in the context of Hong Kong. So I think that's a very important feature. And relating to that, also with exit arbitration compared to other arbitration, is that exit arbitration's annulment procedures or set-aside procedures are not before any national courts. It's before an ad hoc committee that's constituted under the exit panels, and therefore they are not going to be influenced by any political considerations or potential. I'm not saying that national courts necessarily would be, but it will be truly independent by these very experienced and excellent arbitrators who are on these panels. So I think that's one thing. So the important point I really want to highlight is that since last year, Hong Kong is already able to enter into agreements with other countries to use exit as a dispute resolution mechanism, of course, together with other things like the ancestral arbitration rules and so on.
Thank you, Teresa. You have mentioned more the international scenes. Now, let's move on to a lot of the livelihood of lawyers in Hong Kong, the disputes between the mainland and Hong Kong companies. Okay, now what's the arrangements between Hong Kong, the mainland, in respect of investment types of disputes?
That's a very also interesting and important question, and I think that will tally back exactly into what Justice Lam have been saying. Under the Closer Economic Partnership Agreement, the CEPA, on the investment side between Hong Kong and mainland, we have actually adopted mediation as the only dispute resolution mechanism to resolve disputes between investor and the host jurisdiction. So a Hong Kong investor investing into the mainland, if there is dispute, it will be resolved by mediation. And I thought that is a very innovative, if I may say so, in all the investment arrangements that I can see in the world, I can say. If you look at all the other jurisdictions, all the number of over 3,000 BITs that have been entered around the world, they tend to use arbitration and only arbitration. Hong Kong and mainland, whilst it's not a treaty, but of course it's an agreement, will have exactly the same sort of substantive protection on investment protection, but also allowing mediation as the only dispute resolution mechanism. And so therefore, when we were trying to promote using mediation, actually we had a number of conferences on international investment disputes and protection. We've actually used mediation and using CEPA as the as a model by which a number of other places have looked at. And for example, UNCITRAL have been looking at that, and we've shared our experience with UNCITRAL into the mediation for international investment disputes. And so all these things become very important and therefore very innovative, I think, between Hong Kong and mainland, being able to use that, use mediation as the only dispute resolution mechanism.
Thank you, Teresa. It is interesting to note that the Asian community using the Cantonese words Yeuk-wah, okay, or always promote peace. Okay? Many of the Asian countries are now having mooting. Okay? Previously, it was also it's always on investor-state arbitrations. Many now, I think the up-and-coming one is actually in Sri Lanka. They will be having the investor-state mediation mooting competitions. Okay, so a lot of the Asian states are really seriously entering into this investor-state mediation competition. Okay, now, next question is actually directed to Dr. So Thomas. You are the chairman of EBRAM. Okay. During the COVID times, I think a lot of us cannot even go out to dim sum or yum cha. Okay, we rely very much on the video conferencing systems, a lot of things, the arbitration goes online, etc. Now, you're the chairman of EBRAM. Now, so amongst the major arbitration hubs around the world, so what sets Hong Kong apart as a preferred seat?
Thank you, Ronald. First of all, I would like to echo first a comment made by Tony just now, because it also is relevant to what I'm going to answer you. Tony was saying, enough is not enough. Sufficient is not enough. We have to do better. And that actually explained the background of why we have EBRAM, and also the attitude of Hong Kong people, including the legal professions and the dispute resolution community. In that, although we enjoy a very high ranking of our international dispute resolution services around the world, but our people working in the community, our people working in this industry sector, legal professions and arbitration mediation community, share the same view. Sufficient is not enough, we have to do better. And hence, we have EBRAM, because EBRAM is there to add on to the already very well ranked dispute resolution system that we have, the institutions and the judiciary, in that we provide an online and law tech support to our already very good dispute resolution mechanism. So the first factor that I would say is the drive of our legal professions and the drive of the people who work in the dispute resolution sector in Hong Kong. That help to continue to push our quality of services to the highest level. So that is first. And second, I think it has to do with Hong Kong's geographical location. We are located at the gateway of China, and business people in Hong Kong will do a lot of, and the figures also support that, China-related transactions. Deal making and dispute resolution are alike. So because of that, in Hong Kong, I think many people would agree with me. I think we have the highest number of Chinese English bilingual speaking legal professionals than any other arbitration hubs around the world. And these professionals are not only just fluent in the languages, but they are also familiar with the cultural nuisance of both East and West. And that is an added value in serving investors and clients from all over the world in Hong Kong on their deals and on their disputes. And second, which I still think that not many people around the world still know of this fact, is that in the dispute resolution arena, Hong Kong has this arrangement with mainland China where if you have a Hong Kong-seated arbitration in any of the 7, I think including now Nick Chan's institute, 7 recognized arbitral institute in Hong Kong. Once you have that case started in a Hong Kong arbitral institute, you could make use of that arrangement to apply for interim measures, including injunction, freezing of assets, freezing of evidence in the mainland through the mainland court. So that is unique, I think, to Hong Kong when it comes to using Hong Kong as a dispute resolution center. And I still think that this is still not very well known around the world. So I would like to use this opportunity to explain to people who come from abroad that this is unique to Hong Kong, and to me, I think this is also one of the most important factors that set us aside from our colleagues from our other institute from around the world.
Thank you, Thomas. Obviously, as mentioned previously, China is the second biggest economy in the world, okay? And fast climbing up, and hopefully soon will be the top economy in the world. So Hong Kong has that system, obviously, will encourage more business coming to Hong Kong to do business. Now, so Thomas, what has Hong Kong done to maintain the state-of-the-art legislation on arbitration?
Thank you, Ronald. I think our Secretary of Justice, Ms. Rimsky, you and Teresa have said a lot about the government, what we have done, the government has done over the past years on mediation arbitration. But if we are only talking on arbitration alone, recently, I think that many of us in the arbitration field are already aware of that, but many people who are not in the arbitration probably do not know about this, which is that we have legislation now allowed clients to have some sort of third-party funded arbitration, so allowing a funding option instead of parties funding the whole arbitration out of their own pocket. They can consider engaging a third-party funders to fund their case. So that is the first, which is recently allowed in recent legislation. And most recently, I think we now have even further another option, which is that parties can opt for an outcome-related fee arrangement with the lawyers. Okay, so lawyers acting for parties now can reach a fee arrangement with the parties in handling that arbitration with a number of options. You know, either you can still charge according to the hour, you can fix fee, or you can have a mix of a conditional fee together with some sort of reward as a result of the result of the arbitration, or you could actually have the whole fee arrangement linked to the outcome of the arbitration. So these legislation actually enable parties to have more options to seek funding in pushing forward an arbitration in Hong Kong. And that obviously is another advantage to investors, to parties who might wish to choose Hong Kong as an arbitration venue.
Well, thank you, Thomas. The next question I will ask Nick. A couple of minutes ago, Thomas mentioned Nick's organization. I'm certain that you're going to mention your organization, AALCO, very shortly. Now, the question I want to ask you is, I mean, in geopolitics, I hear it on the news every day. I mean, the risk of decoupling and the rise of economies in the East, businesses and countries are stepping up their investments, corporations, and sales and marketing activities in Africa, the Middle East, and more countries in Asia. With more contracts, one can anticipate more disputes and an increased need for dispute resolutions. Now, parties to the contract, the disputes may be from different countries and do not share the same legal system. Obviously, I think Thomas mentioned culture before, or even language. Now, what dispute resolution forums would you recommend to contracting parties? Because we're talking about doing business in Hong Kong.
Thank you, Ronald. There's so many great lawyers in the room, and I see a lot of business people in the room too. So usually, sometimes you get the answer would be, it depends. It's fact specific.
I hope this is not your answer.
Oh, well, you know, send you the bill first. But I'd say I'll echo, you know, what Justice Lam mentioned at the start, parties' autonomy. We have to respect that. So what is best is what's best for them. So let's generalize, a hypothetical case of a company or country A or company A do business with country B or business in country B. They want to find a way to work together, collaborate, do deals as, my professor Teresa often talks about deal making. They want to do deals. But if there's going to be problems, and there will be problems if you do a lot of deals, how do you resolve it cost effectively? Use ODR as Thomas at eBrand would do, on non-dispute resolution. Make use of the APEC ODR, collaborative framework for resolving disputes, mediation, then arbitration. So it's really not about, who ends up drawing the, a shortest straw or playing, some paper scissors. But I think the best forum for dispute, firstly, and say yes if you agree, it's Hong Kong, right? Choose Hong Kong. Many good reasons advocated by all of my seniors mentioned earlier. I won't repeat them. But another thing to think about, of course, is when people do business, especially if it involves a country or involves a party from another country, you want to find a mechanism that allows you to enforce that judgment, the fairness. If you have a court decision made in country A, is it necessarily enforceable in country B, C, D to C? Not that likely, right? I think people in the room will recognize. But within our country, because of one country, two systems, we have ways we could, enforce commercial, civil, judgments. But otherwise, it's not that easy, generally. So I would say, forum-wise, think about, well, if not court, I fully respect the court, of course, Justice Lam, not get me wrong, but I know judiciary also promote mediation. Mediate first, as the Department of Justice always push forward as well. So mediate, conciliate, and if it doesn't work out, have a way that you could speed up your dispute resolution. There'll be arbitration, right? And with the New York Convention, and 173 countries now, is that right? That you can enforce it? Yes, or 4. But then, if you do business, as you do more business in new places, new avenues, new countries that you haven't done business in, or have different cultures and laws and languages, I would strongly recommend you try us out at AALCO, AALCO, Asian African Legal Consultative Organization, established in 1956 after the 1955 Bandung Conference. We are an intergovernment organization, so truly country neutral, and we are not owned or separate, by a particular country. We don't have, founders who continue to run it, so to speak. It's not Nick's center. Thank you, Ronald. It is for everybody. It is. We operate under auspices of AALCO, headquartered in the middle of India. Asia and Africa in India, staffed by diplomats. So I met some of the consul generals here. They immediately recognized AALCO. Of course, I know AALCO. You've been around a long time. That's true. And so we're here to serve. I'm grateful that the 47 countries with host country agreed to set up the 6th regional arbitration center in Hong Kong, and we're here to serve. Check out our model arbitration clause. Back to you. Thank you.
Thank you, Nick. You actually mentioned the 1955 Bandung Conference. Many have said that AALCO is the fruit of success from the Bandung Conference in 1955, and attended by the then Chinese Premier, Mr. Zhou Enlai, who survived an assassination attempt, and also attended by senior representatives from many Asian and African states, now most of which were newly independent at that time, and together they reached a consensus and declared 10 principles of peaceful coexistence. Now, can you share some of those principles that are equally aptly useful to avoid and prevent commercial business-to-business, B2G investor-state disputes?
Thank you, Ronald. If we cast back in time to 1955, a lot of countries newly founded became independent, or gone for a lot of changes. They think about setting up constitution, but in terms of principle, the the 10 principles are there, but generally it's about peaceful coexistence, collaboration, mutual respect, and so on. So if I could maybe just point to 2 of those principles. Principle 8 talks about how we should allow people to have parties' autonomy, respect their preferred means of resolve disputes peacefully by conciliation, mediation, arbitration, and so on. So that's equally applicable today as we do business. You know, if you win, it became a zero-sum game, and it's hard for you to continue to move on and work more together, collaborate together. Then, as Principle 10, that talks about the need to respect each other and respect international obligations. Thank you.
Thank you, Nick. Now, I'm going to ask Rimsky a rather interesting question, I would say. Yes, you, Rimsky.
Why not Poon?
Poon has disappeared. Now, why should parties choose Hong Kong and not Singapore as a seat of arbitration? Nice and short questions.
Nick would give the answer, it depends. No, I'm just kidding. Well, on a serious note, I think this is a question which, to be honest, has been asked many times on different occasions. Speaking for myself, I take the view that one cannot say one city is better than another city. I think the question really boils down to what is the need of the end user. Because different contracts would have different requirements. Say, if you are talking about an energy arbitration, the considerations would be different from an arbitration arising from a private equity dispute, because they involve different considerations, they call for different talents. Now, as for Hong Kong, I think there are a number of features which I would emphasize, and I would urge end users to take that into account when considering where to go for arbitration. The first thing is, in terms of experience, I think HKIAC has a long history. And in fact, Hong Kong has a very long history of handling arbitration. Believe it or not, the earliest documents that we have seen about arbitration in Hong Kong date back to 18-something. And our HKIAC was established in the early 1980s. So you would appreciate the experience that HKIAC has accumulated in terms of handling arbitration. And of course now, as of now, although I'm wearing the hat of a co-chair of HKIAC, but if speaking from the angle of Hong Kong does have other arbitration institutes whereby people can in fact consider their strength and decide which one to go for once they consider the seat of Hong Kong as an appropriate arbitration seat for their disputes. So experience is one thing. I've mentioned about legislation, which I emphasize time and again because I really believe that you cannot have arbitration in a vacuum. So the legislation in Hong Kong, together with the rules administered by HKIAC, are another factor which I would emphasize as an attraction as to why Hong Kong is a good place for arbitration. Because as I alluded to earlier, if you look at the legislative development of dispute resolution legislation in Hong Kong over the past 10 years, I dare say you do not find so many improvements and changes which take into account the evolving needs of the international community in other jurisdictions, whether in the Asia-Pacific region or beyond. The third point I would emphasize is the point which, again, I have alluded to earlier, and that is the Secretariat. And I repeat that internationally, the Secretary of HKIAC has been highly regarded, and they're really efficient in handling cases. The next point is the point which Thomas has emphasized earlier, and that is it would be of extreme importance if you are having a dispute with a mainland enterprise. Because in Hong Kong, thanks to Teresa, we now have the arrangement made with mainland China, whereby we have the court-aided interim measure. As Thomas mentioned very briefly just now, effectively it would allow you to have injunction. Injunction in the aspect, injunction is the word that we common law lawyers use. But effectively, you can have injunctive relief by way of interim measures, first of all, to preserve your opponent's funding. In other words, like the river injunction, like a freezing order in England. If you suspect that your opponent is trying to siphon away his money, his access, his funds away from mainland China, then you can go strict and apply for this court-aided interim measure to freeze the funds of your opponent. If you're concerned that your opponent is trying to do away with material evidence, similarly, this interim measure can be of assistance. So in other words, apart from preserving the funds, so that if you, when you win, you can ensure that your award would not be a paper award. You would be able to put your hands into your opponent's funding. You can also preserve the evidence so as to ensure that there could be a fair trial. Now, this is something which really distinguishes Hong Kong from many other jurisdictions, including Singapore, because if you go to Singapore, if you have the same problems, you can't do it. But in Hong Kong, for instance, if you do it through HKIAC, so far, I think ever since the implementation of the arrangement, what we have seen is that the speed, the efficiency at which the court in China handle applications made through HKIAC are really, really effective. In many of the cases, the injunction order was obtained in a week or even less time. So you can imagine how effective it is if you're having disputes with businesses in China. On the whole, I think when you are thinking of arbitration, I think the end users need to know what are his needs in that specific case, with reference to the facts, with reference to the unique nature of a particular contract. And with proper legal advice, I'm sure the end user, the parties to the dispute or the parties to the contract can decide which jurisdictions is best for the disputes in question. But as between Hong Kong and Singapore, I think Hong Kong does have quite a number of strengths which we would urge parties to disputes to consider. And perhaps if I may just add one footnote, admittedly Singapore and Hong Kong are international cities. But if you are thinking about dispute resolution, you would necessarily think about the legal profession and the dispute resolution community. I think the footnote that I would add is not only does Hong Kong has a very extensive pool of talents from different backgrounds who can handle different sorts of disputes, the legal market in Hong Kong is very open. I think you can compare how foreign law firms can operate in Hong Kong and Singapore, and you will see how Hong Kong is open in that sense and liberal in that sense when it comes to the legal profession. I think so much for that for the time being. Thank you, Ronald.
Thank you, Rimsky. Now, Thomas, I have asked a challenging questions to Rimsky. comparing Hong Kong and Singapore. On a more broad basis, I think we have all heard about how Hong Kong has lost its touch. It is not a viable arbitral seat anymore. It is biased, etc. Why is Hong Kong? Can you tell me why Hong Kong is still a viable arbitral seat?
Well, I would not just say it's viable. It is still the preferred arbitral seat. And the reason is very simple. First, we have heard from Justice Johnson Lam. That's very important. Our judiciary is independent and is going very strong in terms of its independence. And it is clearly demonstrated in the CFA judgment and a number of court judgment that our judiciary is very supportive to our dispute resolution mechanism in Hong Kong, particularly the arbitration sector. In that, people coming to Hong Kong to do an arbitration, you need not worry about halfway through, suddenly you get an order from the local court to stay your proceedings. Because that, if I remember correctly, rarely happen in Hong Kong, not in my recollection of court cases, unless in really obvious circumstances that the court would do that. That is first. And second, our Hong Kong court is always ready to assist arbitral proceedings, and the quality of our judiciary in that we have specialized judges assigned to deal with arbitration-related court applications. So, and secondly, back to the drive to do better drive of our Hong Kong people, particularly if we look at the government, what they have done over the years, starting from Rimsky, then Teresa, then Paul. We have seen all these legislation that I have just outlined just now, arbitration related, mediation related, generally supportive of doing more dispute resolution in Hong Kong. You have mediation, you have arbitration, you have negotiation, plus the fact that willing to bring the level of services to its next level, to do better, to provide parties with more choices when they come to Hong Kong to choose the form of dispute resolution service that they need. Now that is very important. If you look at, Ronald, we went to a breakfast this morning, the local cafe, you remember? There's this set breakfast menu, pork in soup macaroni, and then toast, and then tea, right?
You don't have to stay what I had this
$50.
morning.
Right, in Hong Kong, you go there, you say, sorry waiter, can I not have ham, but then I have chicken and not macaroni, but vermicelli or noodles, and can I not have a toast, but just plain bread, and not tea, please coffee. And they will say yes, same price, okay? But if you go to a number of places, I was told, some tourists come to Hong Kong, when I was trying to order it like that, they would say, oh, can you do that? I thought that, in many countries, you can only order what is there in the menu. And that is the attitude that I'm going to tell all of you, particularly from abroad, that even in terms of our dispute resolution service, we have that mindset. In that, you have more options. You can choose mediation, negotiation, arbitration. You can choose different arbitral tribunals. You can choose different arbitration institute. We have 7 that are recognized that you can go for interim measure in China. You can even choose different type of dispute resolution mechanism. Just now, Nick has introduced, we have some form of multi-layer dispute resolution format like APEC, where it's suitable to a certain type of dispute. The amount, for example, is not a lot, but then you need to have a resolution within 3 months, okay, at a affordable price and very efficient. And even now, we have seen the market is changing. I think the dispute resolution service providers are reacting to the market demand, what the client wants, in so much so that For example, EBRAM, we are there to promote use of technology in dispute resolution arena. We have sensed that there is a demand from the market. Some of the chambers where they have members, they have a particular type of disputes where their members see need a special type of dispute resolution mechanism online, okay? Because they also want to promote use of technology. They also want to digitalize the way they do business, and EBRAM is now helping them to set their own platform and to tailor-make a form of dispute resolution mechanism, specially tailor-made for their members, suitable for their special type of dispute. So that is also something I think is unique to Hong Kong in that starting from the government level to dispute resolution service provider to legal profession, we are there, we have this drive to do better and to serve the client's demand. For different type of cases, we can use different type of dispute resolution mechanism, even tailor-made for your use. I think that actually makes Hong Kong, not just a viable venue, but should be the preferred venue.
Thank you, Thomas, for stating exactly what I had this morning for breakfast with you. And we have repeatedly heard about interim measures. I've actually lost count how many times these two words were mentioned. Now, Teresa, when you were the SJ, you signed the mutual arrangement with the Supreme People's Court on interim measures. Initially, I was about to ask you what it is and how it was done, but of course, we've got so many speakers already mentioning interim measures. So instead, I'm going to ask you, do you have any war stories to tell us on interim measures? I mean, especially bearing in mind that Hong Kong already grants interim measures in aid of foreign arbitration. And you have heard, obviously, how it benefits Hong Kong. Anything further to add?
Well, Ron, you are suggesting that I might breach confidentiality of negotiations with the CPG, huh?
I never mentioned those words.
Now, but there are war stories, and these are not in the capacity when I was SJ, so I can happily talk about it. The first time I myself, in the capacity as an arbitration practitioner, mentioned interim measure, asking the Supreme People's Court to open up interim measure was back in 2016 when I visited the Supreme People's Court. So they were very open, and they've asked the 4th Division, which is responsible for foreign-related and arbitration disputes in China, to look specifically into the matter. So in a way, the seed was sown back in 2016. 2017, I was invited by the Supreme People's Court to talk about this idea. Now, as you quite rightly mentioned, Ron, in Hong Kong, we've always been able to grant interim measure, whether it be court or arbitral tribunal, and if it is court, it can grant interim measure in aid of foreign arbitration, meaning in aid of a mainland arbitration. So in a way, it's very difficult to ask, effectively, the Supreme People's Court to do something which we already are doing. In other words, there isn't really a negotiation, there isn't a give and take. It seems that we are more or less ticking. But once I explained the rationale of why the mainland should allow Hong Kong to do it, I think they very easily agree to it. The first point is one country, two systems. So they appreciate that given the two systems, it should be recognized, and yet within one country, there should be something specially arranged. And I think in answer to one of Ron's question, what's the distinction between Hong Kong and Singapore? I think it is exactly that. And we have the benefit of unique arrangements between Hong Kong and mainland compared to anywhere else in the world. And Hong Kong is the first, and one of the other two is, of course, Macau. So the second point that I think the war story is to explain to them the importance of using Hong Kong as an opening up measure or opening up pilot scheme, bearing in mind that at one stage, China's opening up will probably be faced with a lot more interim measures application. So allowing Hong Kong's arbitral parties to actually try and work out there will be a very good experience even for the mainland. And thirdly, of course, most importantly actually, is the access to justice. I think once understanding the importance of allowing interim measures to be implemented and to be obtained more easily in various places will be a very important tool for access to justice. So I think it's not a matter of Chinese parties. I would say that this arrangement for interim measure is very important for China-related disputes, because I think a number of the applications were not made against Chinese parties, were actually made against foreign parties. But China, it could be their evidence are there, it could be their assets are there that are being preserved under this particular arrangement when the parties were actually arbitrating in Hong Kong. So I think those are the war stories that I could happily share. And of course, I think the one country, two system really makes it a very important reason why we are able to secure that from the Supreme People's Court.
Thank you, Teresa. I don't think you have breached any confidentialities. And remember these two words, interim measures. We have repeatedly mentioning this. Now, I think we have talked about arbitration long enough. I'm not going to revert back to mediation. Justice Lam, you talk about the practice direction 31. I think you briefly mentioned about case settlement conference, and as far as I know, there's the mediator-assisted case settlement conference. What are these measures, and whether such procedures can be adopted in commercial litigation?
Yes, thank you. Actually, the title today is Doing Business in a Rapidly Changing World. And being in a rapidly changing world, the judiciary also recognizes that there are changes. And one of the most important, or at least one of the most important features in our civil justice reform is for us as judges to recognize we have a role in case management. And case management embraces not only adjudicating in cases, but as to how a dispute is to be resolved. It's a wider concept than just to do the adjudication part. And in the rules itself, it's also said that one of the aim of the case management is to facilitate and encourage parties to use alternative dispute resolution processes. So the role of a judge has, in fact, has to be changed in light of the rapidly changing world. And I think a lot have been discussed earlier on about why choose Hong Kong, what is the beauty of Hong Kong. One thing that I can gather from the speeches of various speakers is that Hong Kong has the diversity. Hong Kong has given parties the freedom to choose. And as I emphasized at the beginning, Hong Kong respects parties' autonomy in terms of how to resolve the disputes. And it is based on this concept that we firstly promote mediation as a means to resolve dispute, because mediation, if you think about it, can generate solutions to a dispute which neither litigation nor arbitration can provide, because mediator can explore with the party according to their own needs, their own circumstances, their own interests, the option, which very often is not an option opened in terms of legal analysis or legal reasoning, but they are practical, they are readily acceptable to the parties. This sort of bespoke solution for the parties is the beauty of mediation. And that is the reason why we sort of, in the judiciary, we have this idea of judges not playing the role of mediator, but also playing a role steering the party to consider seriously about settlement, and also in the process helping them to analyze the pros and cons of various options. and sometimes the options have to be coming from them. That's parties' autonomy. And the case settlement conference is a without prejudice hearing conducted by a master who often have very immense experience in mediation, who will discuss with the parties as to what options they are open to them. That being a without prejudice process, whatever happened in that hearing would not be disclosed and would not, the master would not be further involved in the case. So there's no question of you being prejudiced by whatever you said. But very often it will be an opportunity for the parties to get together for the first time after they start to litigate and to have a meaningful face-to-face dialogue with each other to talk about their differences. And sometimes this meeting is important. I want to talk about this because this is actually something, as far as I know, some innovation on the part of the judiciary. We tried it in the district court at the moment. And therefore, in commercial dispute, which is usually litigated in the high court, we don't have that for the time being. But being as creative as we are, all of you sitting here, there is no reasons why parties, with the advice of their lawyers, cannot find a way to introduce it in the high court. I see no reasons why, if the parties are requesting that, our high court would not respond to that and providing this as an option. Now, talking about parties' autonomy, of course, you have to have autonomy in deciding the fate of how to resolve the dispute. But at the same time, you have to take responsibility for that. And the way to take responsibility for that is to consider for yourself what is the best way or what are the various possible ways for me to resolve this dispute. It's not just one way. After you go on litigation, keep on litigating or try negotiation. There are actually, in Hong Kong, we have many, many options. And the beauty of Hong Kong is that we embrace all this diversity, and if there is a viable option put forward, the court will seriously consider, and sometimes we actually take the lead in terms of introducing this option. We are not imposing this on you. You can consider it. If you think it is useful, if you think it is helpful, then by all means, raise it up. And that is the thing about CSC, a settlement conference. We even introduced the idea of bringing in a mediator to deal with the case settlement conference together with our case settlement master. That will enhance the effectiveness of it. I think included in the materials in the folder is an alternative dispute resolution in district court pamphlet, which sets out various concepts in it. We have a already established framework in terms of how to proceed with CSC by now. We have guidance note, which is known to the profession. So I really can see potential for this to be used for resolving commercial dispute, not only in the district court, but also in the high court.
Thank you, Justice Lam. I think the key word is the judiciary is not imposing this on the practitioners. Unlike many jurisdictions which has compulsory mediation before the final hearing. I think a lot of the practitioners are embracing this gratuitously and very welcoming. Now, I have been shown this this thing called Time's Up, and I think with so many prominent speakers, I'm going to be cheeky and squeeze in one last question to everyone, okay? Except for Tony, which is got an additional element of it. What advice would you give to our investors globally Okay, and let's start with Nick. Just hold on. For Tony, I think I know that you're very into educating our young professions. So the additional element for you is, what advice would you give to our young practitioners and, of course, to our investors globally? So, Nick, let's start with you.
Thank you. What better place to do business?
20 seconds at most.
It's starting now. What better place to do business and resolve disputes but Hong Kong? All the answers are, I refer you to the program brochure, pages 2 to something, 2 to 5. Number 1 in the world in the freest economy. Number 3 most preferred seat for arbitration. Number 1 environment for IPO. Number 1 lowest tax center. And he's the right place, right time. Thank you.
Thank you, Nick. Rimsky.
Thank you, Ronald. There's a Chinese saying that prevention is better than cure. In terms of dispute resolution, my recommendation is do not think about dispute resolution only after the dispute has arisen. Think about it when you are drafting the contract. And I would recommend when you are preparing your contract of whatever nature, consider whether you need arbitration and consider whether you would like to come to Hong Kong for the reasons that we have outlined. Thank you.
Rimsky. Teresa?
Like I always said before dispute resolution, there has to be deal making. So when you're doing your deals, when you're completing your transactions, plan not only your substantive obligations, but look also into the international arrangements that are in place, such as promotion and protection of investment between Hong Kong and other jurisdictions, as well as the free trade agreements. So these are the international background that Hong Kong has. The next thing that Hong Kong has is rule of law. And please come and experience Hong Kong rather than just read about it in the newspaper, because seeing and experiencing Hong Kong, I assure you, is very different from what you might be reading elsewhere. The third thing, I think, is the innovation and competitiveness of Hong Kong people. We always think of new ideas to meet the demands of the market. And of course, we're very competitive and therefore are able to catch up on anything that we might have lagged behind a little bit in order to jump ahead. So we're very good at the 100-meter sprint.
Thank you, Teresa. Justice Lam?
Yes, I just repeat, we embrace diversity and we embrace creativity. And we know different dispute requires different means to resolve it. They involve different people, different underlying factors. So by all means, exercise your autonomy. Choose the right thing to do.
Thank you, Justice Lam. I'm going to leave the last answer for Tony. Thomas? Any?
Thank you, Ronald. What I will say to investors is this. Choose Hong Kong as a place for you to protect all your legal rights before you make your investment. Because for investors, you would like your investment to be well protected, so you choose Hong Kong as a platform, draft the contract, reach the deal here, use Hong Kong law, use Hong Kong legal professions, not just the legal professions, accountants, professional service, banks, investors, insurers, everyone that you can choose. And as I have mentioned earlier on, there are many options and we are very flexible and we are there to serve.
Thank you, Thomas. Finally, Tony, any final words to our young practitioners and investors?
For our young practitioners, do not think that AI would do you out of a job. You can always do better, therefore never stop learning. For our investors, I think we must recognize that everybody has a choice. But if you were to choose Hong Kong, for all the reasons given by my colleagues, you will feel welcome, you will feel comfortable, and you can sleep well at nights. What more do you want? Thank you.
Thank you, thank you. Finally, Hong Kong welcomes you. So thank you very much. My apologies for a slight overrun. Thank you very much.
Thank you. Thank you very much for insightful sharing. I'm sure we all have very useful takeaways from the session. May I now invite Mr. Sum to present souvenirs to the speakers as a token of appreciation and take a group photo. Some, please. May I also invite Mr. CM Chan, President of the Law Society, on the stage too, to take a group photo and also to present the souvenirs. Oh.
What do we have? One more. Yes. One more. I'm going to tell you what to do. Sorry. Oh,
We now invite Mr. CM Chan to the stage.
Because they've got so many plaques on those already. So we thought that environmental, something that's consumable.
Thank you all. Please be seated.
The discussion of session 1 ends here, and we will now take a 10-minute tea break before moving on to session 2. Please help yourself with some refreshment at the foyer, and as a kind reminder, the online participants do not have to log out of the session, and see you all again at 11:40 a.m.